Hey y'all, what's going on? Just wanted to give you guys a continuation of some more behind the scenes, talking about written discovery. We already talked about disclosures and what we automatically get underneath the new rules here in Texas. We talked about admissions, where we just asked them some simple questions, simple facts, always tending to prove our legal claim. Most of us use the theory of negligence to prove most of our clients' injury claims, and so that is literally what we want to streamline our questions to prove as best as we can. The other form of written discovery we're able to ask the other side is production. That allows me to ask the other side to give me some paperwork, pretty much, or anything in tangible form that's related to their case. Depending on the amount of monetary damages that the injury attorney is seeking here in Texas underneath the new rules, that's going to dictate the number of questions that you're allowed to ask the other side. In our case, especially in one of my cases, I'm asking for $1 million. So it's very important, though, even under the new rules, since I'm asking for that amount of money, I get 25 production questions, 25 interrogatory questions that I can ask. So I'm not limited to the regular 15. And then also the same thing goes with my with my production. So if this was a $250,000 claim that I'm seeking, I would only be limited to 15. But since I'm not, I get a little bit more. So it's very important that you get an attorney that knows the proper questions to ask, but even more importantly, me asking for that amount of money, I bear the burden of proof, or you bear the burden of proof of proving that claim. Not only from a legal strategy standpoint, but it's going to take some heavy lifting in terms of the amount of money it's going to take to be able to prove that claim. So I'm going to need to hire some experts in this particular claim that I'm seeking for my client. Going to need to hire, make sure that my client is facilitated through her treatment correctly. She's seeing the right doctors and all of that good stuff. So just kind of wanted to share with you all some things that we do in the back end to be able to prove your case. So even if you don't hire me, you're at least educated in being able to talk to your attorney, and you can ask them, hey, have you sent out some discovery? Have you sent out some written discovery to the other side? You want to go ahead and send that out as quickly as possible, because then after that, we're also allowed to sit down and kind of get their statements under oath, any witness statements under oath, any other, which we call a deposition, which is sworn testimony under oath. And we're also able to even get, the defendant to be able to come to the table and talk and pretty much share his side of the story. So you want to make sure you get an attorney that will utilize all of the different devices. And that is just some of them. I haven't talked about a subpoena. That's another measure of discovery that we're allowed to use. I mean, the rules are really flexible in terms of allowing us to be able to get access to information that we need to be able to prove our claim. So if you've got any more questions on litigation or your injury claim, I'll be more than happy to answer any of those questions. My name is Attorney Roxelle Richards. I am a injury attorney by day, and then I also do business mentorship by night, where you can check me out at roxelleonline.net. Look forward to seeing you guys. Bye.